and the persons held to be closely associated with or the conduit of the courting of such undue favor and advantage. And also, in light of the occurrences in the context of the investigative and prosecutorial actions of the Ghanaian and UK authorities in the past 4.5 years. So, the OSP confirms the identity of the following individuals. Government Official 1, Individual 1. The individual described as Government Official 1 by the UK court and Individual 1 by the US court is John Dramani Mahama. He is a citizen of Ghana. He was the Vice President of Ghana from 7 January 2009 to 24 July 2012. He was the President of Ghana from 24 July 2012 to 7 January 2017. His tenure of office as the Vice President of Ghana coincided with the time frame of the UK and US investigation of the first Airbus campaign for the sale of 2 C-295 aircraft to Ghana. His term of office as the President of Ghana occurred during the UK and US investigation time frame of the second Airbus campaign for the sale of 1 C-29 aircraft to Ghana. Intermediary 5, Consultant 4. The individual described as Intermediary 5 by the UK court and Consultant 4 by the US court is known both as Samuel Adam Mahama and Samuel Adam Foster. He is a UK citizen and also a citizen of Ghana. He is a younger brother of the full blood of John Dramani Mahama, former president of Ghana, referred to above. His birth name is actually Samuel Adam Mahama, but he was adopted from Ghana and taken to the UK in 1972 by a British missionary couple. He assumed the last name of his adopted parents, Foster, at age 9. He lost touch with his Ghanaian family until 1997. Intermediary 6, Consultant 5. The individual described as Intermediary 6 by the UK court and Consultant 5 by the US court is Philip Sean Middlemas. He is a UK citizen. He is an English television and radio actor and businessman. He is a close friend of Samuel Adam Foster, otherwise known as Samuel Adam Mahama. Intermediary 7. The individual described as Intermediary 7 by the UK court is Leanne Sarah Davis. She is a UK citizen. She is a partner to Philip Sean Middlemas, referred to above. On 30 April 2020, the OSP requested the assistance of Interpol for the issuance of a red notice for the apprehension of Samuel Adam Foster, also known as Samuel Adam Mahama, Philip Sean Middlemas, Leanne Sarah Davis, and Sarah Ferno, the spouse of Samuel Adam Foster. The red notice was published by Interpol on 10 July 2020. On 13 May 2020, the OSP sought and obtained warrants from the Circuit Court Accra for the arrest of Samuel Adam Foster, Philip Sean Middlemas, Leanne Sarah Davis, and Sarah Ferno. In the general scheme of affairs, the Interpol red notice of itself is not an arrest warrant, and it is insufficient to secure the presence in Ghana of the non-resident subjects of the investigation without an accompanying request for extradition. The OSP is not a body mandated by law to request the extradition of suspects from foreign jurisdictions to the Republic. Thus, we could only rely on the agencies mandated by law so to do. In July 2020, the OSP sought, through the Ministry of Foreign Affairs and Regional Integration and the Ghana High Commission in the UK, the voluntary return to Ghana of Samuel Adam Foster, otherwise known as Samuel Adam Mahama, for interviewing by the OSP, since he is a citizen of Ghana, apart from the fact that he is also a citizen of the UK, but these efforts were unsuccessful. There was a pause in the investigation between November 2020 and July 2021, where there was no substantive special prosecutor. The investigation resumed in August 2021 after my assumption to office. By July 2022, it had become obvious that the mutual legal assistance process was yielding precious little. The OSP interviewed former President John Dramani Mahama on 5 January 2024 in Accra. On its own, the OSP located and interviewed Samuel Adam Foster, Philip Sean Middlemas, Leanne Sarah Davis, and Sarah Ferno outside Ghana in March 2024 in the presence of their counsel. Don't ask me where and how we found them. I'll tell you. Now, to our observations. The OSP's mutual legal assistance requested from the UK and US authorities placed the OSP in a position no better than any person who read the DPAs and the decisions of the UK and US courts on the Airbus matter. It was not a lack of industry or want of trying on the part of the OSP. In the end, the OSP had to conduct the investigation on its own without any real help. However, the DPAs and the decisions of the UK and UK courts served as a vital foundation for the OSP investigation. After all, the President's referral to the OSP was on the back of the DPAs and the judicial pronouncements. Therefore, the OSP investigative outcomes are substantially similar to that of the SFO of the United Kingdom and the DOJ of the United States. Our investigation shows, as captured in the UK and US deferred prosecution agreements, that Airbus indeed completed 2 sale campaigns in Ghana in respect of C-295 twin turboprop military transport aircraft manufactured in Spain by a subsidiary of Airbus. The campaigns resulted in the sale of 3 C-295s. The first contract between Ghana and Airbus was signed on 3 August 2011 for the sale of 2 of the aircraft, and the second contract was signed on 5 March 2015 for 1 C-295. The 3 aircraft were delivered to Ghana on 17 November 2011, 19 March 2012, and 4 December 2015, respectively. That is to say, they were actually delivered. The OSP investigation also shows that in the general scheme of affairs, the acquisition of operational assets by the Air Force is driven by national and operational requirements. So when a need is identified, the Air Force Command develops a technical paper upon which providers are requested to make presentations on technical details, logistics support, and cost. If a provider meets the requirements, a formal contract in the form of a sales and purchase agreement are drafted by the provider for the consideration of the Air Force. Thereafter, stakeholder meetings are held among representatives of the Air Force, Attorney General's Department, Department of Legal Services of the Ministry of Defense, the Judge Advocate General's Office, and the provider, all aimed at arriving at a consensus on outstanding issues and conflicting positions and resulting amendments to the draft agreement. Thereafter, the agreement is submitted to the Ministry of Defense for cabinet and parliamentary approvals. The Air Force then constitutes a compliance team to work closely with the provider to ensure that the delivered item meets the agreed specifications. Ladies and gentlemen of the media, the processes leading to the purchase by the government of Ghana of 3 C-295 twin turboprop military transport aircraft from Airbus followed substantially the same pattern. Parliament approved the proposed transactions in 2011. In accordance with the laws of Ghana, in the estimation of the OSP, there was nothing remarkable about the deal, and it certainly would not have found its way in the UK and US deferred prosecution agreements and made headlines around the world, but for the involvement of former President John Dramani Mahama and his younger brother of the full blood, Samuel Adam Foster, also known as Samuel Adam Mahama, and his associates, as recounted in the UK and US deferred prosecution agreements. The OSP investigation found no evidence that former President Mahama was involved or played any role in the procurement and maintenance of the agency relationship between Airbus and Foster and his associates in respect of the purchase by the government of Ghana of military transport aircraft from Airbus. And it appears to the OSP that the direct communications and meetings between former President Mahama and officials of Airbus to close the deal were actuated by good intentions on the part of the former president. It also appears that Foster and his associates became involved as intermediaries in the Airbus Ghana deal after the decision by the government of Ghana in preference of the C-295 aircraft. Therefore, it seems that Foster's Airbus intermediary role at the time his brother served as the vice president of Ghana was a case of luckless coincidence that attracted the disapproval of the UK and US authorities. The OSP found no evidence that suggests that the involvement of Foster as an intermediary of Airbus and the direct communications and meetings between former President Mahama and officials of Airbus to close the deal between Airbus and the government of Ghana amounted to any corruption and corruption-related offense in respect of which the OSP has a mandate. However, it ought reasonably to have occurred to former President Mahama and the government of Ghana that the familiar relationship between former President Mahama and Foster and the direct participation by former President Mahama in the communications and meetings with Airbus officials were bound to raise reasonable suspicions of improper conduct and dealings, notwithstanding any claims to good faith conduct and above-board dealings, especially in light of the fact that during the first Airbus campaign, former President Mahama was the chairman of the Armed Forces Council by reason of his position as the vice president, and therefore a very key decision maker. Such close proximity dealings by such elected high officials of the Republic and their kin and close associates on behalf of the Republic should neither be viewed favorably nor encouraged, as they give rise to reasonable suspicion of influence peddling and conflict of interest, never mind any intended good faith on the part of the vice president or the president. Then again, the direct participation of the president and the vice president on behalf of the Republic in commercial communications and meetings with commercial entities should not be encouraged either, as they expose these elected high officials to the specter of the slightest hint of perceived corruption that may attend international business transactions. The president and the vice president should be insulated from such direct commercial dealings. Indeed, it seems to the OSP that the only reasons why the Airbus Ghana deal found its way into the UK and US DPAs were the fact that former President Mahama and Samuel Adam Foster were brothers of the full blood, and that former President Mahama directly participated in commercial communications and meetings with Airbus officials. This is because, and here, without seeking to critique the UK and US deferred prosecution agreements, the OSP found no evidence, circumstantial or direct, which suggests that Foster and his associates were actually paid bribes, and which bribes were to be transmitted to former President Mahama, and that the bribes were actually paid to former President Mahama. Indeed, to all intents and purposes, and objectively viewed, an agency relationship existed between Airbus and Foster and his associates, by which Foster and his associates acted as business partners of Airbus in respect of the Airbus Ghana deal, and under which Foster and his associates were to be remunerated success-based commission payments. I'm a woman, so I expect that. This was a typical arrangement instituted by Airbus, by which it contracted third parties as business partners to increase its international footprint and to assist it in winning sales contracts in numerous jurisdictions. On this basis, when Airbus made a successful sale of aircraft, it will ordinarily pay a business partner a commission-based percentage value of the sale or a fixed amount of the aircraft. In this context, Airbus took the full benefit of the agency agreement with Foster and his associates and the services they provided to Airbus for a considerable length of time. This was so because the contract for the sale of the first 295s between Airbus and Ghana, which was clearly secured by Foster and his associates, was signed almost 2 months before Airbus issued its due diligence report on 30 September 2011, which led to the abrogation of the arrangement between Airbus and Foster and his associates. It was only when Airbus due diligence mechanism discovered the familiar relationship between former President Mahama and Foster that it abrogated the relationship. The abrogation by Airbus of the agency arrangement certainly portended to work, and did in fact work grave unfairness against Foster and his associates. Therefore, the concoction of a plan by senior leadership in SMO International and the Defense and Space Division of Airbus to deliberately circumvent Airbus compliance rules by substituting Company D, or the company owned by Consultant 4 and Consultant 5, with the Spanish intermediary 8 Organization 1 to ensure payments to Foster and his associates, was probably a well-intentioned adventure, though apparently misguided, as it rendered the payments seemingly of doubtful provenance. Whose phone is this? Your girlfriend is calling. It also appears to the OSP that the relationship between Airbus and Foster and his associates was neither one-off nor peculiar to the Airbus Ghana deal. Airbus had in place similar business partnership models with Foster and his associates in respect of business promotion in other African countries before the Airbus Ghana transaction. As we stated above, the UK and US deferred prosecution agreements did not include and cover the reference individuals. The agreed settlements were reached by the UK and US authorities with Airbus only, and it appears that Airbus accepted criminal culpability for bribery for itself and also vicariously on behalf of the reference individuals, including its employees, agents, business partners, and Ghanaian public officials, and that the reference individuals appeared not to have been direct subjects of the investigation by the UK and US authorities and were not afforded the opportunity, if they were so minded to take it, to explain their actions and to present exculpatory evidence, if any. The OSP is unaware of any such analogous proceedings or framework in Ghana by which an entity could vicariously accept wholesale criminal responsibility on behalf of another, especially where that other was not a direct subject of the investigation and was available to answer for himself, but was not afforded the opportunity to do so and to present any exculpatory evidence he may have. Though the UK and US deferred prosecution agreements were emphatic that Airbus failed to prevent persons associated with it from bribing others concerned with the purchase of military transport aircraft by the government of Ghana, and that the bribes were intended to obtain or retain business or advantage in the conduct of business for Airbus, and further that the payments were intended to induce or reward improper favor by former President John Dramani Mahama toward Airbus. The conclusions by the UK and US authorities appear to be solely from the perspective of Airbus and what Airbus perceived as the real intentions of its employees in their dealings with their intermediaries and the government of Ghana. The OSP does not question the conclusions of the UK and US authorities. This is so, especially as the OSP is not privy to the raw body of evidence available to the UK and US authorities, apart from the content of the DPAs, which you may have all read. However, it seems to us that the nature and structure of Ghana's statutory prohibitions and our jurisprudence on corruption and corruption-related offenses do not lend themselves to founding criminal culpability in respect of the reference individuals in the context of the UK and US outcomes. It seems to us that since the reference individuals were not represented during the UK and US investigations, it became a case of whatever characterization Airbus placed on their conduct in relation to the actions of the employees of Airbus. It is also obvious that Airbus did not represent and had no intention of representing the interest of the reference individuals. It appears to us that the sole aim of Airbus was to save its image and reputation, never mind what it did to the image and reputation of the reference individuals, and to pay fines to avoid prosecution. Therefore, by reconstructing the entirety of Airbus dealings in Ghana, and through its intermediaries and with Ghanaian public officials, the OSP looking at it from both the perspective of the officials of Airbus and that of the Airbus intermediaries and Ghanaian public officials, it seems to us that what Airbus perceived and accepted in the deferred prosecution agreements as the real intentions of its employees in their dealings with the intermediaries and Ghanaian public officials is at cross purposes with what appear to be the real intentions and expectations of the intermediaries and the Ghanaian public officials in their dealings with the employees of Airbus. This is what I'm saying. While the accepted facts in the two foreign jurisdictions are that the employees of Airbus designed the payments to the intermediaries as bribes intended to court favor with Ghanaian public officials, especially ex-President John Dramani Mahama. On the other hand, the intermediaries appeared to expect and receive the payments as their legitimate expectation under an arrangement of success-based commissions for the sale of the military transport aircraft to the government of Ghana. And their actions, in whichever way viewed, were calculated as businessmen expecting their lawful paychecks and not as conduits of a bribery scheme. The concoction of a plan by senior leadership in SMO International and the Defense and Space Division of Airbus to deliberately circumvent Airbus compliance rules by substituting Company D, or the company owned by Consultant 4 and Consultant 5, with Spanish Intermediary 8, or Organization 1, to ensure payments to Foster and his associates, though wrongful and deceptive, was entirely an internal matter for Airbus in respect of its disciplinary regulations and code of ethics. It does not amount to the payment of bribes to court favor with Ghanaian public officials in the reckoning of Ghanaian law. It is a case of the employees of Airbus deceiving Airbus. Neither does the short declaration by Airbus to the Spanish Export Credit Agency and Airbus's non-declaration in the context of the US ITAR. Consequently, the OSP has no evidentiary basis upon which to conclude that Samuel Adam Foster, also known as Samuel Adam Mahama, Philip Sean Middlemis, and Leanne Sarah Davis acted as conduits of bribery between the employees of Airbus and former President John Dramani Mahama or any other public official. Also, the OSP found no evidentiary basis that suggests that Samuel Adam Foster, also known as Samuel Adam Mahama, Philip Sean Middlemis, and Leanne Sarah Davis received payments from Airbus with the intention of bribing former President John Dramani Mahama or any other public official. Further, the OSP found no evidentiary basis that suggests that former President John Dramani Mahama or any other public official was paid bribes by Samuel Adam Foster, also known as Samuel Adam Mahama, Philip Sean Middlemis, and Leanne Sarah Davis in respect of the purchase by the government of Ghana of military transport aircraft from Airbus. Then again, the OSP found no evidentiary basis that suggests that former President John Dramani Mahama or any other public official was induced to improperly favor or did improperly favor Airbus in respect of the purchase by the government of Ghana of military transport aircraft from Airbus. In the case of Sarah Feno, she should not even have been a subject of the OSP investigation. Members of the media, the OSP has cited and notes that by two separate communications, both dated 22 April 2021, the SFO in the United Kingdom notified Samuel Adam Foster and Philip Sean Middlemis that a decision had been taken not to prosecute them for any offense in respect of the Airbus Ghana deal. It has not come to the notice of the OSP that the SFO in the UK has reconsidered its decision. We consider it ties with our conclusion. Further action. A special prosecutor has directed the closure of the OSP investigation into alleged bribery of high-ranking Ghanaian officials by Airbus SC through intermediaries in respect of the sale of military transport aircraft by Airbus SC to the Republic of Ghana between 2009 and 2015. The OSP would not institute criminal proceedings against any person in respect of this investigation. The special prosecutor has also directed authorized officers of the OSP to rescind the 13 May 2020 warrants of arrest obtained from the Circuit Court, Accra, for the arrest of Samuel Adam Foster, also known as Samuel Adam Mahama, Philip Sean Middlemas, Leanne Sarah Davis, and Sarah Feno. Earlier today, I sent out correspondence notifying Interpol of the withdrawal of the red notices in respect of Samuel Adam Foster, also known as Samuel Adam Mahama, Philip Sean Middlemas, Leanne Sarah Davis, and Sarah Feno. Thank you for your kind coverage.